Hi, this is Dan Patrick, Ohio native, and you're listening to Auto Smarts for You.
Well, thank you, Daniel. And he is the pride of the Cincinnati area, Mason to be exact. Welcome back to Auto Smarts for You as presented by Germain.com. I'm Randy, along with your host, Boots and Lex. And this is the time where we have the award-winning feature every week as presented by Lex, and we love to call it Lex Flex. Lex, what do you have?
You know, we have obviously some great content coming up talking about the defense and the way to navigate the world when you are charged with a DUI. But I thought it would be important to talk about the state of DUIs in Ohio and kind of what we're showing as far as the state, how we're driving. And as of last year, we had, 1,172 deaths, fatality pertaining to DUI related.
That's all?
Well, that's
not a lot.
Interesting statement that you just made.
I thought it would be a lot more than that, though.
You know, I did think it would be a lot more than that, and I was actually really encouraged when it said in July 4th of 2009, we had the fewest fatalities in a decade pertaining to drunk driving or driving while under the influence. So we had fewer deaths in a decade this past July 4th, 2009. And I want to talk to our lawyer friend who we've now just befriended when he gets on to see why he thinks that is. Does he think people are smartening up and wisening up about driving while under the influence? But, you know, unfortunately, people have done it. You know, you've made a bad choice. Yeah. People don't realize the legal limit is you have to be, 0.08. That's your blood alcohol content.
I think that's too strict.
But the tricky part about that is it depends on your weight. It depends on all sorts of factors. So people always say things like, well, I can I can handle 8 beers. But what they don't realize is the policeman doesn't know you, doesn't care you can tolerate. They care what your blood says.
I fear one thing with the policeman. And yes, we both have a lot of good friends that are Columbus police officers. But I'm talking about the branches of the world. I sometimes think if it's the kind of their high to bust some people. I would love to be a little fly on the wall if hearing officers have a discussion and I nailed 3 last night that barely blew illegal.
You think it's a competition?
I think some of the divisions, I think they really take it to a level of, you know, like the defensive back that puts a good hit on a wide receiver. I get that feeling. You know, if a guy's falling down drunk, I understand that, but I miss the days of old, of back in the day where we heard the guy had a few beers and he knew the local policeman. He rode him home this time, but next time I'm going to hang you out to dry. And unfortunately, in today's society, there's too much finger pointing, and we live in a no-blame world. Now, we're not telling people to drink and drive for sure,
right?
But I think there has to be a happy medium.
But I think when Ben gets on, obviously he's the attorney that he's graciously entering the lion's den with us. But what people don't realize is when it's all said and done, you're well over thousands upon thousands upon thousands of dollars when you get a lawyer involved trying to combat that DUI offense. So why wouldn't you just pay $60 to get a cab or, you know, pony up? Maybe it's $40, maybe it's $100, so that you don't need to go into the world of paying thousands upon thousands upon thousands of dollars for making a bad choice,
exactly.
Right?
Yeah.
Well, let's find out more about that. We are joined now by Ben Luftman from the firm of Luftman, Heck and Associates. And welcome to Auto Smarts for You as presented by Germain.com.
Well, thank you very much. I'm very happy to be here.
We have tossed you into the middle of this ring here right now. Let's get your thoughts on what Lex had to say.
Boy, where to start? There were a lot of different thoughts there, so I guess I'll just try and take it one by one. In regard to the number of fatalities and the lesser in the number of fatalities in terms of people wisening up, et cetera, you know, I think it's very interesting. Clearly, there's a great push about DUIs and driving drunk and, you know, trying to keep people from not getting in the car. I don't know if you guys have seen or the listeners out there, but I know that the television has been flooded by, there's the commercial with a guy who's in his car and it's full of beer, and he gets in there and then you know, he unrolls the window and it just falls out and, you know, over the limit, under arrest, you know. I mean, and I think it sticks in the public conscious a little bit, quite frankly. So I think that might have something to do with the decrease. Also, they've done a lot of things with the police departments called No Refusal Weekend, where if you go and you say, you know, I don't want to take a breath test, they will have judges on standby who will go and they have to get warrants signed to draw your blood. They'll say, if you're not going to take the breath test, we're going to take you to a hospital and we're going to have your blood drawn.
Right.
And for the people that still refuse, they'll call the judges 2 o'clock in the morning, 3 o'clock in the morning. I know I've had these cases in Franklin County. They do them in Delaware. and the judges, they'll say, this is why think I have probable cause to think they're under the influence, and the judge will listen to that. If they determine there's probable cause, they'll sign the warrant, take them to the hospital, and they'll take their blood.
And by that point, people, just so you know, the alcohol is not out of your system yet. So you're not in the clear.
No, and not in the slightest.
Right.
In regard to, Boots' comment about, is .08 too much or too little? I go and speak at a drive intervention program where people who've been convicted, I've spoken to a number of them actually, they have to go for a weekend. It's 72 consecutive hours. It's the mandatory minimum alternative to 3 days in jail on a first offense OVI. Now, just to back up real quick, if you blow over a 1.7, which is a high test, then you have a mandatory minimum of 3 days in jail and a 3-day drive intervention program or 6 days in jail.
Okay.
And so, when you're there and you're talking about, what you have to go through to even get to that point, back to Alexa's point, you go, you get arrested, and you get your license suspended immediately, either for 90 days if you blow or a year if you refuse, at least initially. And you have to go and pay for an attorney. You have to have your license suspended. You have to go and, in terms of how you're driving and everything, just to work and school purposes really is all it's supposed to be. So very much curtailed. You have to go through that. You have to take off work to come to court. Potentially you end up with an OVI conviction on your record. Then if you have a conviction, if you get convicted, instead of a 90-day suspension through the Bureau of Motor Vehicles, originally if you blow, it ends up being what's called a Class 5 license suspension, which is actually 6 months to 3 years.
So not only are you having to pay money, but now you're losing money because you can't really work or you can't really go anywhere. You can't further your life. So it's this it's a spiral down effect. It's awful.
I mean, it's definitely not ideal.
Right.
I mean, I finished the thing, and then ultimately they have to go and spend 3 days where they have to pay $400+ to do that. Also $475, I believe, to get their license back, which is the reinstatement fee.
So would you guess that a DUI is going to cost a person, once all the smoke clears, we're $4,000 to $5,000?
Without question.
My buddy,
and
unfortunately, was in that situation, and it was $12,000.
How many DUIs?
That was the first, but there were obviously
We gotta give
factors.
him
But
your
it
number.
could be as much as $12,000 for him, whereas a cab was $60. I mean, there's no contest there.
I got to ask the magic question.
Sure.
Because this is the main reason I contacted you.
Right.
And again, let me start off by saying we don't want you drinking and driving, period. I'm against it. I never was for it. Now, my wife has been unfortunate where she has to chauffeur me around after I have a few beers. But I've had 3 beers, say, the wife's at work, I don't have a ride, and I think I'm fine, and I've been pulled over. Now, I know I'm not falling down drunk, but I know I'm at that line. Sure. So give me not what I should do or what I should expect, and I'm going to let you run with that, and then I'll do my evaluation. Me and Lex will give you after you're done.
It's interesting because we had discussed this prior to being on the air, and I actually went and, we talked about that there are charts where it says, well, if you've had this many drinks and you're this amount of weight, then you should blow or not blow, or what you think anyways your blood alcohol content would be.
Okay.
And, just to back up, I guess, and give a little bit of education, here in Ohio, according to the Ohio Revised Code, Section 4511.19, it's operating a vehicle while under the influence of alcohol and or drugs on any public highway or private roadway in the state of Ohio. Now, within what an actual OVI is, there are 2 types of OVIs. There's an OVI impaired, which is very subjective, and it includes how you were driving, how you pulled over, how you looked, how you smelled, what you said to the officer, and also how you did on the field sobriety test. It's all about the officer, trooper, deputy's opinions of that, so it's all subjective. Okay. And on the other hand, you have an OVI per se, which is a breath test. And here in the state of Ohio, the limit is 0.08 grams per 210 liters of breath. And it used to be 0.10, as I'm sure that you guys probably remember it.
That was only, what, like 10 years ago?
Yeah,
was that?
I'd say approximately.
When it changed?
That's pretty close. And there's been a lot of changes in the Ohio Revised Code in regard to OVI. Just actually skipping back for a second, in January of 2004, they actually overhauled the Ohio Revised Code. And prior to that, it was actually OMVI, which is operation of a motor vehicle while under the influence. And so January 1st of 2004, the Ohio legislature went and overhauled the Ohio Revised Code, and subsequent, it's been OVI, which is operation of a vehicle. And I was talking to Boots, in my own personal practice, cases that I've seen subsequent to that, I've seen OVI high tests on bicycles.
Wow.
I've seen OVIs on lawnmowers.
Lawnmowers, yeah.
Lawnmowers, no question about it.
Yeah.
I've seen OVI horse and buggy out of the Amish area.
Wait, a drunken Amish guy?
In Ohio? Absolutely.
Now, wait, hold that thought, because we were on a break, and let's do this break, because I don't want to get too deep, because I have so much to go with you.
Yeah.
So let's get this break out of the way, Randy, and then we'll...
Yeah, we'll talk, too, with Ben Luftman some more out of Luftman, Heck, and Associates, and maybe talk about what he feels is the constitutionality, perhaps, of sobriety checkpoints. Should they be allowed? And again, your calls, too. We've got Mike on the line. We'll get to him in just a second. 821-1230 if you have a question. This is Auto Smarts for You, as presented by Germain.com.
This is Mayor Michael Coleman, and you're listening to Auto Smarts for You.
And welcome back to the program, as presented by Germain.com. It is Boots. It is Lex. I'm Randy. And we have a caller here, guys. And it is Mike who has a question from Hilliard. Mike, good morning. You're on Auto Smarts for You, as presented by Germain.com.
Good morning, Randy. How are you?
Morning. How are you, Doctor?
Morning, Mike.
Fine. Guys, I just have one question. I have a CDL, which I believe it ups the ante because I don't have a right to refuse. If I refuse, they take my license for a year. There's no questions asked on getting my CDL back. Is that correct?
Okay, I'm sorry. That was the end of the question. Yeah, the issue with going and refusing the CDL, I mean, there are a number of different issues with that. If you go and do refuse, then they do up the penalty on you. Conversely, I know situations where I've represented people with CDLs where that's happened. Sometimes you can go, and if there's an issue with the reason why they went and stopped you, and you can argue that and potentially successfully terminate the administrative license suspension, then you might be able to get around that. Also, in regard to resolving a case, I know with the CDL guys, as opposed to, sometimes you talk about amending it to a lesser offense and, whether or not a reckless operation charge or a physical control charge is an appropriate amendment. And it's my understanding that the physical control charge is not a serious traffic offense in the CDL. So if you're able to go and do something like that and also deal with the administrative license suspension, which is, as I was telling Boots before, whenever I go and dealing with the case, I always try to negotiate both the case itself to try and get a lesser offense to give my client some options, as well as the license suspension. So it's something that subsequently, might be able to be taken care of. And to be honest with you, if it's a situation where it was given in to you and there wasn't, a reason to go and do it, then potentially you wouldn't be penalized at a later point in time.
All right. It was the way I understood it is if I'm pulled over and I refuse to blow, I lose my license for 1 year, no questions asked.
Well, if you get convicted of an OVI, you're going to lose your license for a year as well. So,
Okay.
Is there any way at that point, as an attorney, that you can fight? Say this Mike guy gets pulled over. He's got his CDLs. He refused to blow. As an attorney, he can't lose his license for a year. That could cost him his job.
Sure.
If he has CDLs, evidently he's driving a big truck. But as an attorney, how do you? I don't want that guy losing his job because he had 3 or 4 beers and got pulled over. See, I always get this in my head. Most people, I picture the drunk drivers when I was a kid. There was 5 town drunks. They always drove drunk, and them people should have been in jail. I'm talking about the guy that's leaving the Christmas party that doesn't blow. How, as an attorney, do you go to that judge and say, look, he's got his CDL, he can't lose his license for the year, he only had 3 or 4 beers, or how do you defend him?
I doubt that's his defense.
No, I don't know.
Right
That's
there.
I can't begin to understand how you would defend that.
Right.
Yeah, well, I wish that the good guy defense was a winner, because believe me, I would never lose the case.
Really?
Don't get me wrong, I'm not a good guy.
Oh. Wow.
Wow. Thanks, Mike, for sharing.
All right, then.
Well, how goes that defense for you? I guess there's got to be one in every crowd. In regard to your question, Boots, I think that you have to attack it in a couple different ways, and ultimately it potentially could be the judge's decision if you litigated the case, meaning that you had a hearing on whether or not there was a reason to go and stop somebody to begin with.
Okay.
And then if they decided that there wasn't, and that the refusal potentially might go away at that point in time. I mean, I would say it's pretty rare, personally, in my practice, to go and see that. But to be honest, in the reality of it is, most of the CDL guys that I know that, and ultimately went and took a breath test.
Okay.
And so at that point in time, they take the test and you say they blow over, but you possibly can still go and get what's called a stay, depending on where you are. And a stay basically puts somebody's administrative license suspension on ice. And so for the time being, they can go back and get their full licensure back, potentially, and then you can go and deal with it from there.
Okay.
Mike, we hope that helps you out.
All right, thanks a lot, guys.
All right, thanks a lot. Ben, let me ask you a question. By the way, we are talking to Ben Luftman. He is with the law firm of Luftman, Heck & Associates at 580 East Rich Street. We'll give you more information in just a second. The constitutionality of sobriety checkpoints, and this could be two questions. Can you address that? Plus, the fairness of sobriety checkpoints. Could you have, say, let me call it transportation profiling, for lack of a better term?
Well, I think that the answers to your question, it has been something that's been litigated, and courts have decided on, what they think of checkpoints. Mm-hmm. And they have said that checkpoints are okay, even though, usually to back up, I just want to say, I actually went through the same testing that an officer does to go and be certified to do the field sobriety test, which would basically equate to an arrest. I was cadet Luftman for an entire weekend.
That's cool.
And, during that time, I went through, saw all the videos and everything that they had to go and do. And they basically break down an OVI arrest into 3 different phases. And the first phase is the vehicle in motion phase. And basically that talks about, a person's driving. And there are roughly 26 cues or clues, that's how they're said, that could potentially indicate impaired driving, because isn't that what it's about, impaired driving?
Right,
so
right.
I'm going to get to your point in regard to that, because maybe you don't see that when you stop somebody at a checkpoint. The second phase is the personal contact phase. So that's when an officer comes up to a person's car and they're talking with them, and that actually breaks down a little bit further, where they're supposed to use their senses, including their sense of sight, their sense of hearing, and their sense of smell. And there are various cues or clues potentially that could indicate impairment from that. Slurred speech, bloodshot glassy eyes, odor of alcohol, inability to answer questions properly, inability to get, they'll ask you for license registration, proof of insurance, inability to go and do that, giving confusing responses, odor of marijuana coming from the vehicle. All of these things they're taught to go and look for when they're at the car. And then lastly would be the pre-arrest screening phase. And during the pre-arrest screening phase, that's when they go and do the standardized field sobriety tests on you. Generally speaking, they go and give 3 standardized field sobriety tests. One is a horizontal gaze nystagmus test, where they go and put an object across your field of vision. Right.
Uh-huh.
Second, where they ask you to do what's called a walk and turn test, where they ask you to stand and then take 9 steps heel to toe, arms at your sides, watching your feet and counting your steps out loud. Turn using a series of small steps, and then again take 9 steps heel to toe, counting your steps out loud. And then lastly, a 1-leg stand test, where they'll ask you to stand, raise 1 leg, either leg approximately 6 inches off the ground with your foot parallel to the ground. They ask you to keep your arms at your sides, maintain eye contact with your feet at all times, and then count out loud until they tell you to stop, which in the NHTSA manual, NHTSA being the National Highway Traffic Safety Administration, is to roughly 30 seconds or more. So going back to your point,
wow.
all of that is very subjective, okay?
Yeah, and I'm having trouble keeping up with that. I'm not toasted right now, so
no,
honest.
some of those tests, I've known people that's drank a lot and pass all those tests. I know this one-town drunk used to practice those tests.
Oh, no.
Sure.
No, I do. I know a guy that did that.
I'll say 2 things to that, and I'm going to come back to your point on the checkpoint as well. In regard to the field sobriety test, one thing that I would always argue, that there are 2 different ways to look about it from a defense attorney's perspective. One is in regard to admissibility, and the other is in regard to the weight of the evidence itself. In regard to admissibility, according to the National Highway Traffic Safety Administration, there are certain ways where they're supposed to demonstrate and instruct the test so that you're doing it properly. The tests themselves are called standardized field sobriety tests. They are pseudo-scientific tests, meaning that they're supposed to be done the same way every time. When I go and speak at my 3-day programs, I say, imagine your chemistry class from high school, and they go and give you a list of instructions of how you're supposed to go and do something. And if you go and follow those instructions exactly as they're given, you're going to come up with a reliable result. Mm-hmm. Okay. Well, it's sort of the same way on this. You're supposed to go and do the demonstrations and instructions the same way every time, because that'll yield a reliable result. And in the National Highway Traffic Safety Administration manual, which is like 700 pages, there are only 2 places in that entire manual where it talks about something in all bold and all caps, which, as we all know, means pay really close attention to this. One is how officer safety, how they're supposed to position themselves relative to you with their gun so that you can't go for it. The second way is that an officer needs to go and do the demonstrations and instructions exactly as they're given in the manual, because failure to do so could yield unreliable results.
Okay.
So, if they're not doing that right, then in terms of the admissibility, a judge could decide, well, they didn't do these with substantial compliance, and we're going to throw them out. In regard to weight, which would get to your question, is someone doing it well? Conversely, other people doing it poorly, we're all born with different a balance and coordination to begin with. And if somebody is not used to doing these tests, who does this stuff on a regular basis, and maybe they're out there at 2 o'clock in the morning, they're scared, trying to figure out all these demonstrations and instructions and maybe not doing it as well, I would say that how much weight does a jury really want to go and give that?
Right.
Doubling back around to what you said originally, so the whole point of it is trying to see somebody who's actually operating their vehicle and showing some sort of indication of impairment, of impaired driving. In regard to one of those stops, they're not necessarily showing that. Cars slow down and then they just stop cars randomly and then pull them out and then, talk with them and decide whether or not they want to go and do field sobriety tests. As I said to you, it's been decided through case law, which is judge-made law, that those are in fact constitutional, provided that they go and give notice in advance of where it's going to be, and then they're not profiling, certain people, that it's, an arbitrary car that you're going every 3rd car and you're just going and speaking with them.
Right. We are up against a break, and we'll have more from Ben Luftman. Luftman, Heck & Associates. As we head into break, again, your street address, your internet location, all the information?
Sure. The street address is 580 East Ridge Street. We're located right downtown in Columbus, Ohio. It's 43215. The internet address is www.lawlh.com. That's www.lawlh.com. And our phone number at the office is area code 614-224-1500.
Okay, the witness may step down for a couple of minutes, if that's okay.
Thank you.
All right, we'll take a break. This is Auto Smarts for You, is presented by Germain.com. No.
I don't know how you do.
Welcome back to Auto Smarts for You, is presented by Germain.com.
Well, I want to get right to the steak and potatoes here. If a guy gets pulled over and he's had beers and he knows he's on the limit, I'm going to ask, should he blow? Should he not blow? Give me the rundown of your steps a person should take.
Boots, seeing as how I've never been asked that question before, I'm going to have to take a second to collect myself and try and answer.
I bet you haven't. Because that's a question I've always heard.
And try and answer it appropriately. Well, it's interesting for me as an attorney what to say in that situation. And, generally speaking, I don't think there is any pat answer. And I'll tell you why. Because, they have some lists that say if you've had X amount of drinks, either mixed drinks or beers, and you are X amount of weight, then this should be your blood alcohol content, or potentially it might be.
Okay.
And, I've gone and looked at those lists, and I actually gave you a couple as well that you're looking at. And there are a couple of them that I've given you, and one is from a study that was done, and the other is through the National Highway Traffic Safety Administration. And the interesting thing about those lists is that the drinks and the weight are there, but the actual potential BACs are different on those lists.
Right.
And when you're talking about something so fractional that could get you charged with an OVI, if you're 0.08, they can charge you with the OVI per se. If you're 0.081, they can charge you. And so the way that I explain that question, because I get asked it honestly every time I do the drive intervention program that I speak at, it is like this. I'm not going to tell you whether or not to blow or not to blow. Mm-hmm. But what I can tell you is, like I was talking originally, there are 2 types of OVIs. And if you put out your hands, on the left hand, you have an OVI impaired. And that's very subjective. All things that can be argued about. How you were driving, how you pulled over, how you looked, how you smelled, what you said to the officer, and how you did on the field sobriety test.
Okay.
So they can say, hey, you look bad, and you can say, no, I didn't. and a jury would decide ultimately whether or not that was the case. And just talking a little bit more about the law, in Ohio, to go and have a jury, the legal standard is beyond a reasonable doubt. If we had everybody in this room and, you were sitting in judgment of Lex, and you were supposed to cite, dun, 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 whether or not she was guilty of operating a vehicle under the influence,
right,
you guys would have to be as convinced as you would be in making any of your own most important life's decisions. I mean, that's basically what it comes down to. You would have to be so convinced, healthcare for yourself or for your family, that's how sure you'd have to be that she was operating a vehicle under the influence with the subjective standard, okay?
Okay.
But if it's under the objective standard, which is on your right hand, which is the OVI per se, which is a breath test or a blood test or a urine test that's over the limit, it's one objective scientific standard. So then we'd have to say, well, the machine was working properly, and when Lex tested over a 0.08. And that's all you guys would have to believe. As long as you believe that the machine was working properly, you didn't have any doubt that it was, and that her test was over that and the people were properly qualified to give it, she'd be guilty. But on the left hand, if you had some doubt as to, how much weight to give the field sobriety test or anything like that, then potentially, if you didn't believe beyond a reasonable doubt, then you would have to find not guilty.
Right.
So in regard to your question, you have your two hands. You have your subjective on the one hand and your objective on the other. If you don't take the breath test, then you can ball up your right hand in a fist, put it in your pocket, and what do you have left? You have your left hand, you have subjective things that can all be argued about, as opposed to if you still have the right hand there, it's very hard to argue against the breath test. And so if you don't do the field sobriety test, then you have even less to go and argue about as well. So take that for what it's worth.
So do you have to? Okay, so we've got the right hand closed out with all the scientific stuff.
Right.
So so basically, I'm saying, okay, I know I've had, according to this chart, I can have 5 beers. So I've had 6 beers. I'm at that limit. So I'm refusing all the tests. I've refused all that. Now on my left hand, do I have to take the field sobriety? Do I have to do his pen test? Do I have to walk the 9 steps and do all that?
Well, I think it breaks down a couple different ways. No, you don't. However, there are certain penalties associated with failing to do so because, in order to have the privilege and pleasure of having a Ohio driver's license, you agree to go and take any tests that an officer would ask you to go and do. So, if you refuse to go and do those tests, there are penalties that are associated with it, including an increased license suspension, where if you take the test and you take the breath test, it's a 90-day license suspension, at least originally. And if you refuse to go and do those tests, it's a 1-year license suspension.
Okay.
All right, Ben. Can you hang around for one more segment?
Sure.
All right, we'll take a quick break. This is Auto Smarts for You, as presented by Germain.com.